Okay, the legal prophet is my name. We are still proceeding with our Jurisprudence 1, and we are going to look at what we call the relationship or the relationship between law and the state. So, as I told you, law is already clearly known, but we have to know what the state is. So, the word state comes from a Latin word known as status. Status is status, which means standing. So we are going to see that a state is the highest standing or is the highest form of human association. So it is the highest, it is waguru, it is the highest form of human standing. You have to know basically a state is comprised of what we call the judiciary, the legislature, and the executive. So when we look at the definition of a state as per the different scholars, we are going to see Woodrow Wilson. Woodrow Wilson, you remember him, for those who did History 3, Woodrow Wilson defined a state to be a set of people organized for law within a definite territory. So it is a state. A state is a set of people organized for law within a definite territory. Within a definite territory. That's the way it defined what a state is. So we have to know the elements of the state. So for those that will do or do public international law, you have to know the different elements or the components of a state. One, it must have a defined territory. When you look at the map of Uganda, that territory that shows Uganda is what we call a state. To population, it must have population. You cannot have a state without a population, so it must have a population. It must have a government. A government must be that one that is aiming or that governs the society, judiciary, executive, and the legislature. Then sovereignty. It must be sovereign. Those are the elements of the state. So you can classify the state into two. There is what we call the ancient state. That one, it comprises of monarchy. Go back to England. That is the ancient state, monarchy. Bafugibwa bwa kabaka. Then the modern state. Today the modern state is governed by the central government. Then there are different theories for the origin of the state, but I will not go into them. There is the evolutionary theory, the social contract theory, the fourth theory, the divine theory. I won't go much into those. So we have to know the functions of a state. So the state has two functions. One, primary functions. Two, the secondary functions. So the primary functions, the primary function of the state is to protect the integrity and the territory of that state and to maintain law and order. So the primary objectives of the state or functions of the state: one, maintenance of law and order; two, to defend the territory of the state. Those are the primary: defend the territory, to maintain law and order. Then the secondary functions or objectives of the state is to require or to ensure that the people or the citizens are in a well-living or the welfare of to ensure the welfare or the well-being of the people. So the secondary function of the state is to ensure that the citizens are living in a well-established environment or a welfare of the people. So then when we go to the relationship between the state and the law, we are going to see their relationship in 2-3. One, state is superior to the law. So when you look at Austin in his command theory, for him he said that the state is superior than the law, meaning that the law is under the state. So Austin says that the state is superior than the law. Then we are going to see that there is another one: law is superior to the state. So this one was said by Jaring. Jaring is a socialist who belongs to the social school of jurisprudence. So to Jaring, he said that no, the law is superior than the state. Then the others say that the state and the law are the same. That is Kelsen. For Hans Kelsen, for him, he said no, there is no difference between the law and the state. The state and the law are very much similar. So the relationship is seen in 3:1. Law is superior, that is Austin. 2, law is superior, that is Jaring. The state is superior, that is Austin. Then the state and the law are equal, that is Hans Kelsen. Now we also have to know the concepts of the law and the state based on the various scholars. I begin by Karl Marx. So Karl Marx said that the law is there to be used as a tool for the ruling class to oppress or to maintain their power. So the law, to Karl Marx, it is that tool that is used to suppress we the people to maintain their power. Two, Austin had to talk about coercion. The law and the state or the state should use all coercive measures to punish those that disobey any of them. Bentham had to come up with the utilitarianism theory, the theory of the general happiness of the people, the greatest happiness of the people, that the law should be that one that is used to promote the happiness or the general happiness of the people. Again, Bentham has what we call the hedonism theory, the theory of pain and pleasure. Again, he says that the law should not be that one that only brings pain, but should at the same time bring pleasure to the people. So those are some of the concepts or the scholarly views on what we call law and the state. Thank you for listening.